Hello, everybody. My name is TJ Scott, and I'm an estate planning attorney with the Law Office of Timothy J. Scott. I'm so happy that you've decided to join me here tonight. We're going to be talking about something that I know is a touchy subject. I know that can be really hard to talk about, but I also believe that knowledge is power, and that's what I want to do here tonight. I want to give you information, I want to educate you, and I want to empower you about this topic so that it doesn't have to feel so scary, so that it can be something that you approach with some peace of mind. So I have a lot of information that I want to give to you today, but I also want to encourage, if you have questions, that you make sure to bring those questions to me, because I love answering questions and being able to give information that way as well. I do have some valuable offers I'm going to be making at the end of the presentation, so I hope that you'll stay with me so that you can see what those offers are. All right, the best way to learn, the best way to be here with me tonight and to absorb the most information is to be present. I encourage you to turn off distractions if you have another tab open or if you have the TV on. I encourage you to set aside this time that you've chosen to get educated on estate planning. Give yourself this time. I always say your future self is going to thank you for putting your attention here, focusing on this topic, and making sure that you have the information that you need to be able to move forward. I've mentioned this a couple of times. If you stick around until the end, I have a couple of offers that I want to make to you. The first is a free virtual one-on-one meeting that we can have where we can talk about the different topics that we talk about tonight, and we can get really specific to what that looks like in your situation. Plus, I have a bonus gift as well that's going to make it even easier to get a tailored custom estate plan put in place for the people that you love. All right, this is going to be a little interactive because it's it can be a little difficult if I don't include a little interactiveness. So the first interactive poll that I have, it should be up on the screen now. The question is, do you have an estate plan in place? And so I hope that you'll let me know if you have an estate plan already in place right now. I'm seeing almost exclusively no's. In fact, I am seeing exclusively no's so far. The things that are listed here on the screen are parts of an estate plan. So when we talk about estate planning, it's really a collection of a number of different things. It might include a trust. It likely includes a will. It may include guardianship nominations if you have minor children. Incapacity planning documents like a healthcare directive, power of attorney are also very important to have. And then beneficiary designations also play a role in planning your estate and making sure that your assets go to the people that you want. So again, I see almost exclusively that people don't have an estate plan in place, and I understand that. And I hope that you don't feel like I'm putting you on the spot by noting that. You're not alone. In fact, let me share a statistic with you here. Something like 69% of people in America today don't have an estate plan in place. And there are lots of reasons for this. In fact, I'm going to go ahead and ask you, if you don't have an estate plan in place, why not? Maybe one of these things resonates with you, or maybe multiple of these things resonate with you. Maybe you feel like you're too busy, and trust me, I completely get it. As a father of 4 and somebody who is running their own business, life today is ridiculously busy. If that's the case for you, I just want to commend you for setting aside time to be with me tonight. I know that it's not easy. 7 p.m. on a Wednesday, generally there's not a lot else going on, but at the same time, it's a real commitment to set that time aside and be with me here tonight. And I really just want to commend you for taking this time to educate yourself about this topic and to maybe get the ball rolling if you're ready to do that. Maybe you feel like you're too young, and I do see somebody saying that they have been too young, or they feel like they are too young to get this done. And the truth is, anyone over the age of 18 should really have some kind of estate plan in place. I recently helped a young family where a young father had passed away, and he'd left something of a mess for his wife and minor daughters, but it didn't have to be that way. You can get a great estate plan in place, and it can be an estate plan that grows with you as well. Maybe you feel like estate planning is too expensive. And I see a lot of people say, I'm worried about estate planning being too expensive. I promise you, I'm going to speak directly to that point, exactly what you can expect to spend for an estate plan in a little bit here tonight. But I just want to address that quickly and say, estate planning used to just be for the wealthy. That's true. It used to be Uncle Scrooge McDuck type stuff. but not anymore. With the advent of word processors, with the advent of different softwares that are making this more and more accessible, estate planning really is for everybody, especially for the middle class, especially if you have a family and some assets that you want to take care of and that you want the right thing to happen with. Maybe you're worried about jinxing yourself. And I do see some people admitting that they're worried about jinxing themselves. And for that, I just have a little bit of good news that I can share with you. I have done dozens of estate plans. In fact, I've done hundreds of estate plans, and I have never seen a correlation between somebody getting an estate plan done and having something negative happen in their life. It just doesn't happen. I always say, I think that my clients tend to live without this on their shoulders. They tend to get more out of life and enjoy life a little bit more because it's not something that they're worried about anymore. It's been taken care of. And so I hope that you feel that way. I hope that you can understand how good it would feel to have this done. All right, let's say if you do have an estate plan in place, or if you don't have an estate plan in place, but something on the screen really resonates with you, tell me what it is. Maybe you're wondering if an online or do-it-yourself will is okay and is going to take care of your family. And I know I've reviewed a number of online wills. Sometimes they can range from this is a pretty good basic plan to, oh gosh, we really got to get this fixed. It's not doing what you want it to do. But there are some people that an online will works for, and I'm going to talk about that a little bit later tonight. Maybe you're worried about whether your estate plan could be outdated. And this is especially true. Maybe you have an estate plan that names guardian for minor kids, but your kids aren't minor kids anymore, and you want to know, is my 24-year-old daughter going to have to live with my sister if something happens to me? And the good news there is no, the court's smart enough not to give guardianship over your 24-year-old to your sister. But there are things that change. There are things that change in the law. There are things that change in your family and with your assets that mean that your estate plan might need a second pair of eyes. It might need somebody to look over it and make sure that it's not outdated. And I see a lot of people saying that they just want to better understand their plan. And I take that to also mean that maybe you just want to better understand this topic of estate planning. And I promise you that that you should have some takeaways here tonight, because I am going to be sharing a lot of information, a lot of very poignant information, and I will make it as simple as I possibly can, so that you can definitely have a takeaway here today. So if you have a specific question, and I see somebody is already posting in the chat here some specific questions, I hope that you'll put that question into the chat box. And I see here a question: what's the difference between a trust that goes into effect when I die versus having a trust set up now while I'm living? And what are the current benefits of having a trust versus planning for assets to not go to probate when we die, and for designating beneficiaries? So these are some fantastic questions. I'm definitely going to address these tonight. Very quickly, the difference between a trust that goes into effect when you die and a trust that you set up right now. The first is called a testamentary trust, because it uses a testamentary document, something like a will, to spring into being. So it's a springing trust or a testamentary trust. It springs into being when you die. A lot of what I'm going to be talking about tonight is called a living trust or a revocable trust. And that's a trust that you create during your life and that you put assets in during your life. And the great advantage of a living trust or a revocable trust is that you know that it's in place. It can help you to avoid probate in a way that a testamentary trust can't. And there are some other ways to plan around probate, but it can be difficult. There are ways to plan with beneficiary designations and things like transfer on death deeds. But having a living trust or a revocable trust in place is a really fantastic way to kind of cut through everything and have a very simple plan that is going to definitely avoid probate when you die. I see somebody saying, I'm interested in trust to avoid probate costs, confidentiality, etc. That's fantastic. I'm going to be speaking significantly about that, about the costs of probate, about the public nature of probate, and the fact that everything has to be filed with the probate court. Everything becomes public. So that's great. I'm really happy to see that. And then the question about the current benefits of having a trust versus planning for assets to not go through probate. Again, having a trust in place now is a way of planning for your assets to avoid probate when you die. And for designating beneficiaries, I'm going to talk a little bit about beneficiaries and how that works as well here tonight. Fantastic questions. I hope that you'll keep them coming, because if you have a question, it's very likely that somebody else on the line is going to have that question or a very similar question. So please keep asking. And thank you also for sharing in the polls. It's fantastic to see, and it's going to help guide our conversation here tonight. All right. I want to let you know that you're in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you filled in an online will or a do-it-yourself will, but you're not sure if it's going to work the way that you want it to work. And you're in the right place if you're nervous about how much this is going to cost. I completely understand that. Again, I'm a father of 4. I understand being sensitive to cost and wanting things to be done for the right price and to be done as simply as possible. I'm going to talk significantly about that cost component and about what you can expect to pay to have an estate plan written for you a little bit later here tonight to address that in particular. But I just want you to feel like you're in the right place, and I have information that's going to be useful to you here tonight. And the reality is, estate planning isn't about us. And this is something that really occurred to my wife and I when we were updating our estate plan recently. It's not going to enrich us. It's not like starting a business or, being an entrepreneur or investing money. It's not exactly like that. Really, estate planning is done for the people that you love, so that after you're gone, they don't have a lot of cleanup to do. It's making sure that you're taking care of them. It's really a gift that you're giving to them. And the truth is that your loved ones are going to know. They're going to know whether or not you lived up to your promise to take care of it. And unfortunately, sometimes people will leave a mess for their loved ones to take care of. But that's not going to happen here tonight. I'm going to help give you a lot of guidance about how you can get it taken care of to make sure that your loved ones feel that gift that you've given them and have closure after you're gone. So here are some of the things that we're going to talk about tonight. We're going to talk about planning for incapacity. Incapacity, you can think of as something like a coma or possibly Alzheimer's or dementia, when you can't make decisions for yourself. And that could be decisions about healthcare, decisions about finances. Who can make those decisions for you? And what does that look like? We're also going to talk about planning for when you pass away. And that might mean guardianship if you have minor kids. In fact, I'm going to put one more poll up here to kind of get a feel for how people, what people's situation is that they're joining me from. If you'd share, I would really appreciate it. Minor children, if you have kids under the age of 18, it's very important that you plan for guardianship. And that is planning for who's going to take those kids in the future, but also who can stay with them in the near term. We'll talk about that a little bit, because I do see that there are a number of people with young kids, more with grown kids, more somebody without kids, but there's kind of a smattering of people with young kids, so we'll make sure to spend a little bit of time on that here tonight. We're also going to talk about probate, and we're going to talk about the time that it takes to get through the probate process, as well as the cost of probate and the fact that it is a public proceeding. We're going to talk about estate taxes, and that's a place where I usually get to give people good news. So I get excited about that, being able to give people good news. We're going to talk about unclaimed property and what that is and how property becomes unclaimed and ends up sitting with the Minnesota Department of Unclaimed Property instead of going to an heir or a devotee. And then we're going to talk about intangible assets. And intangible assets are things like your stories and your values. A lot of times people say that they would rather share those stories or values with their loved ones than to have certainty that their assets are going to go to them. And they're really important. It's a really crucial thing. Before we get too deeply into that, I want to share a little bit about me, since we're going to be on kind of a journey here tonight and doing a lot of talking here together. So this is me with my family. My wife's name is Tobin. As I mentioned, I have 4 kids. Bridget is the newest child. And then from left to right here, it's Margaret, Elizabeth, and Ben. And my family is really my whole world. I live with them here in Bloomington, Minnesota. And I graduated from the University of St. Thomas School of Law back in 2012, near the top of my class. And the very next day, my son, Benjamin, was born. After law school, I found a job with a small estate planning and tax preparation law firm, and I loved the clients that I was able to work with, and I loved being able to help people and get ahead of issues with the planning that we were doing. But at the same time, I didn't always feel like I was providing the value that I thought that my clients deserved. And so a little more than 3 years after I joined that firm, I ended up leaving. And this is actually a picture from my last day there. Someone has to graduate at the bottom of the class. Now, this is something that stayed with me. It wasn't said about me, but it's something that has stayed with me that my parents actually said about an extremely negative estate planning experience they had with an estate planning attorney who helped my grandmother. I remember them saying this phrase in particular, someone has to graduate at the bottom of the class. But I actually don't know that attorney, that it had anything to do with that attorney's knowledge or intelligence or, their ability to succeed in law school. I think that attorney was probably practicing under a model that wasn't serving people well, that didn't serve my grandmother well. And I'll talk more about that faulty model. I call it planning for death a little bit later here in the evening. But first, let's talk about some aspects of estate planning. And I really want to start here with guardianship because it's so crucial if you have minor kids. And again, I know not everybody has minor kids, so I will try and get through this quickly. But if you have minor kids or if you know somebody who has minor kids, this is really information that they need to have. There are a couple kinds of guardianship. There's short-term guardianship, and what short-term guardianship means is if the kids are at home staying with a babysitter and something happens to you and there's no plan in place, what is going to happen? And really, eventually that babysitter is going to say, they don't seem like they're coming home. Mr. and Mrs. aren't coming home. I need to call the police and I need to get the police involved. And when the police get involved, they involve Child Protective Services as well. It's just what they do without knowing exactly where those kids can and should go. That's the natural place to send them. It's the lowest liability for the police and everybody involved. Unfortunately, we all know stories about Child Protective Services, and I'm not trying to talk bad about them, but we all know stories about Child Protective Services, and I can tell you, I don't want my kids to spend a single minute with Child Protective Services if I can help it. And that's why short-term guardianship is so important. With short-term guardianship, we can put a plan in place and we can make sure that there's documentation about exactly who those kids should be staying with and that authorizes those people to stay with the kids. Long-term guardianship, on the other hand, is who's going to raise those kids until the age of 18. Sometimes it's the same as short-term guardians. Short-term guardians, you really want to be available and accessible within 20 or 30 minutes of where you live. Long-term guardianship, though, could be anywhere in the country, could be anywhere in the world. It's where you want your kids to go, where you know that they're going to thrive. It's also very important that you name long-term guardians. And the reason is, if you don't name long-term guardians, a judge is going to name those long-term guardians for you. And if Uncle Larry looks like the best person on paper, Uncle Larry has a job and a house with enough rooms for the kids, and he's living locally, well, Uncle Larry might get the kids, even though you know that Uncle Larry should be the last person to have the kids. So it's very important that you, the parents, put this into place so that the kids are staying with the people and in this situation where you know that they're really going to thrive. All right, let's talk about assets. How are the people that you love going to receive the assets after you're gone? And if you don't have an estate plan in place, or your estate plan is hinging on a will, it uses a will to transfer your assets, then the state's estate plan for you is a court process called probate. And probate in Minnesota is slow. It takes a minimum of 6 to 12 months. More often, it's taking something like 12 to 18 months. We'd like it to go faster, but it just can't. It's bureaucratic and it's administrative, and it is a slow process in part because it is an opportunity for your creditors to come forward and make sure that they get paid. Probate's also very costly. Here in Minnesota, we estimate that the cost of probate is something like 3 to 6% of the gross value of your estate. And it includes things like attorney's fees, executor's fees, or personal representative fees, appraiser's fees, filing fees, creditors, and bond premiums, all these different things that leach away from the assets that you want going as an inheritance to the people that you love. Again, 3 to 6% of the gross value of your estate. We'll have a chance to actually estimate what that will be here in just a little bit. But just to kind of give you those numbers for right now. Oh my goodness. Sorry, everyone. All right. And I always say probate is a lawsuit that you have to file against yourself with your own money for the benefit of your creditors. That's exactly what it is, and it's exactly that bad. Probate's also public. So I'm showing you the last will and testament of Anna Nicole Smith, and I'm able to show you this because the will had to be filed publicly. And a lot of people think that a will avoids probate. And in fact, my guess is after I say this, I'll probably get some questions in chat or Q&A about this. Unfortunately, a will ensures that there's a probate. A will has to go to the probate court in order to be interpreted and administered based on those provisions of the will. So that public nature means that unfortunately, creditors might be put on notice of what assets are being distributed out to the people that you love, which is not a good situation. If you have minor kids, then they stand to receive assets at the age of 18 and completely unprotected. And not just this, it can be very expensive to hold onto the assets and to protect the assets until they turn the age of 18 through a process called conservatorship as well. I think that we all know stories about people who receive too much money at a young age or trust funds at too young of an age that they're able to access, and the ways that it can really spoil somebody's financial understanding when they have too much money at a young age. So this is really important that you make sure that the assets go to the people that you love, but they go to the people that you love in a really responsible and caring way that they're able to take care of those assets. Okay, so I promised that there would be a chance to calculate your probate estate, and this is that opportunity. I have here a sample probate estate. You may think that this is a ton of assets. You may think that this is a relatively modest estate. Either way, you can kind of calculate based on this what your estate might cost to go through probate. And I have things on here that don't pass by beneficiary designation, but that have to go through the probate process in order to get to your heirs and devisees. So things like your home, a rental property, furniture and household goods, automobiles, stocks, bonds, and bank accounts, and business interests are all things that don't generally pass by beneficiary designation. They don't automatically go to the person that you have listed to receive that item. And instead, they have to go through the probate process in order to get there. And you can get 5% of the total gross estate value for your estate by moving the comma over one place and then dividing that number in half. And so that's how I got this. The estimated probate costs and fees for this estate might be something like $42,500. And again, you may think that this is a pretty posh estate, or you may think this is a pretty modest estate. But having $42,000 come out of it would be a huge dent in an estate like this, and something that you wouldn't want to have happen, especially knowing that it could be avoided. Here's just an added little wrinkle. Life insurance and retirement accounts generally have a beneficiary named on them, but if that beneficiary is a minor, then unfortunately those assets also need to go through a process called conservatorship that has similar expenses to the probate process. And you can see here how that really all of a sudden explodes, or you know, I'm thinking of a balloon, but I can't think of a good word. It really increases the cost that probate or that your estate would have to pay in order to get those assets to the people that you would want them to go to. I talked a lot about probate, but here is some good news. Probate is voluntary. It can be avoided, and the way to really avoid it is to fully fund what's called a living trust. And a living trust is that trust that you create right now during your lifetime It's something that you create and that you can put assets into. And in fact, the simplest version of what a trust is that I've been able to come up with and that I tell my clients all the time is that you start with assets and you hand them over to someone else. And this person, the person starting with the assets is called the settlor. The person you hand the assets to is called the trustee. And the settlor tells the trustee, this is what I want you to do with those assets that I just gave you. And the trustee says, yes, I promise to handle these assets in the way that you ask me to. That's what a trust is. That's a trust agreement. It's between the person who starts with the property and the person who accepts the property and accepts the terms that they need to deal under in order to deal with the property. A living trust means that you're both the settlor, you're the person who starts with the property, and you're the initial trustee, you're the person who's going to administer those assets. You're also the beneficiary, the person who gets to benefit from those assets during your lifetime. So you're in three kind of different roles, you're wearing three kind of different hats in the trust, but that's the really important part of it, is that you're transferring the assets into your trust so that you're holding onto the assets, not in your personal name anymore, but as trustee. So when something happens to you as trustee and you die, somebody else, the successor trustee, can step into your shoes right away and administer those assets and make sure that they go to the beneficiaries that you have listed after you've passed away. So fully funding a trust, in order to get the assets into your trust, you have to do different things depending on what the asset is. For bank accounts or investment accounts, you have to retitle that into the name of the trust. With an investment account, there's often a form that you just fill out. You may have to get it notarized, likely have to get it notarized. You may have to get it medallion stamped in order to transfer it into the trust, but it should be a relatively simple process that your investment or that your brokerage should be familiar with and should be able to help you with. With bank accounts, you need to go to the bank and sign new signature cards so that you're opening a new account or you're converting your account into a trust account. So it's now a trust bank account instead of a personal bank account. For real property, things like your home, cabin, rental properties, you execute a deed in order to transfer that into your trust. And that's how that goes into the trust. With stock and bond certificates, generally there's a way to transfer those stock and bond certificates. Might be on the back of it. If it's an electronic stock or bond certificate, then there's another way. Maybe you could even name a beneficiary on them. I've seen that sometimes for certain stocks. But that's something that you need to do in order to make sure that that asset gets into your trustee's name so that if when something happens to you, your successor trustee can step up and deal with that property. Personal property is really easy. It goes in with an assignment of personal property. And that's just a single form that says, I hereby put my personal property into the trust. And then life insurance and retirement accounts, including 401k funds, because I see somebody asking about 401ks in the chat, and that's a fantastic question, generally go into the trust after you die by beneficiary designation. So you set the beneficiary up as the trust. And so when you die, then it will automatically pay into the trust. And we write provisions into the trust to deal with those retirement account assets or to deal with the life insurance assets, depending on what it is. Okay, that's a lot. I know that's a lot of information, and I expect that we'll probably see some questions about it. I encourage you to ask any questions that you have that came up based on that conversation about trust and about planning to avoid probate. But here we're going to talk about estate taxes. And this is, as you can see, I think that this is a pretty generous estate. I think that this family would be doing very well for themselves, but they would also be subject to the Minnesota estate tax at this time. The federal estate tax only applies if you have more than $12.06 million. And once you have more than $12.06 million, it does kick in at a pretty steep rate and goes all the way up to 40%. It gets pretty expensive for any money that you have above $12.06 million. Good news is if you're married, you actually get to double that number. So it's over $24 million before you have to pay $1 in estate taxes. In Minnesota, we have an estate tax exemption of $3 million. and that number is not automatically doubled. However, that number can be doubled if you do some estate tax planning ahead of time in your estate planning. I see here, what about real property in other countries? That's a fantastic question. Certain countries have a similar treatment that will allow you to put them into the trust. Other countries have different ways of holding on to the assets other than that. And so it might involve something like a land trust in that country. It might involve something like putting it into a business formation, something like that, and then making sure that you deal with the organization, the business organization documents, so that it goes into your trust. That's something that really varies country by country, and so if that's an issue or a question that you have in particular, I hope that you'll reach out to me, and we can look at the country, and we can look at the laws surrounding the treaties, I should say, surrounding that country and the laws in that country to figure out what needs to happen in order to make sure that real property transfers without having to go through a probate. And I see here, if you're married, is it a joint living trust, or does each person have a living trust? And that's a fantastic question. Generally, I find that most married couples treat their property as joint. Most married couples see all of their property as joint property and treat it that way and understand it that way. And so I find that it generally makes sense to write a joint living trust or a joint trust for married couples. Some attorneys differ on that. Some attorneys decide that if it's a married couple, they still need separate trusts, and that you just associate certain property with the different trust. And there are advantages to that. It's a little bit clearer when somebody passes away exactly what has transferred by the first person's death versus what's going to transfer versus by the second person's death. But generally, I find that it makes the most sense to plan with a joint living trust as opposed to separate trusts. All right, is the tax for an estate in a trust, or is this without a trust? Unfortunately, this does not avoid taxes. This doesn't avoid estate taxes, but having a living trust, having the correct estate planning in place can double that Minnesota exemption. So it's not $3 million anymore, but it's actually $6 million. When the first person passes away, you have, anyway, you're able to double that exemption. So it's not $3 million, but $6 million. Then I have another question here. What happens if there's a trust prior to marriage and you do a prenup to keep each other's assets separate? Yeah, that's a great question. Generally, if you have that agreement to keep your assets separate, it would almost certainly make more sense to plan with separate trusts at that point. And that would be what I would encourage you to do. That's what I would do with a client who had a prenup in place and was treating assets as separate, is make sure that they continue to have that separate asset treatment by doing separate trusts. If you have property in your name only, can you still put that into a joint living trust? The answer to that is yes. The key is that the joint living trust have provisions in the trust to say that any separate property coming into a joint living trust continues to have the same treatment that it had before being put into the trust. And so that means if it's treated as separate ahead of time, you have that provision in there so that it continues to be treated as separate, even though it's now in the joint living trust. But I think that it's simpler if you have significant separate assets that you want to continue to keep separate. I think it makes probably more sense in that situation to have separate trusts instead of joining the trust together. Fantastic question. Really great questions, everybody. Thanks, and keep asking them. Hopefully I've been clear and answered those questions directly enough for you to understand and to have the knowledge going forward about exactly about your question. Okay. Will your assets be lost to the state? And here I'm talking about unclaimed property. Does anyone have any idea how much money is currently in the Minnesota Department of Unclaimed Property? And I'm not going to give you much time to guess. I'm going to show you here. It's over $700 million, and that number is over $58 billion nationwide. And a big part of how that money ends up in departments of unclaimed property is that somebody passes away and the kids, the heirs, the people who are supposed to collect everything aren't aware of where everything is. It's not totally clear. Maybe mom and dad had a main bank account at one bank, but they were also banking at a couple other banks, had smaller accounts at other banks. Maybe there was stock ownership that the kids weren't aware of, that that mom and dad owned stock, something like that. And all of a sudden an asset can become missed and ends up going to the Department of Unclaimed Property. And it can be very difficult to get that property out of the Department of Unclaimed Property. It depends on the institution that's holding it, but I can tell you a lot of times there can be a lot of back and forth, and it can be very difficult to prove that you're the person who has the right to take that property out of there. So it's better to just not lose the property to the Department of Unclaimed Property at all, which is why I create an inventory for my clients of all of their assets. Now we go through everything. We talk about bank accounts and business interests. We talk about real estate, life insurance, retirement accounts, loans that they've given out, all kinds of different things. And we make sure that everything is inventoried. So when something happens to them, their kids can come to me, or their grandkids or whoever it is can come to me and say, what assets did my parents have? What do we need to collect? And it's very easy for the family at that point to make sure that they're able to collect everything, take care of it, and make sure that it goes to the person that you really want it to go to. And this is really cool. You can actually make your living trust a real treasure chest. And when I say this, what I'm talking about is building in asset protection over the assets that go into your trust when they distribute out to your kids. So this is a concept known as a lifetime asset protection trust. And it's very neat because it can actually protect their inheritance from things like a divorcing spouse or a creditor seeking that money in something like a bankruptcy. It's very neat. Not all estate planning attorneys build this in, but it is something that that can be built in. It's not something that you're going to be able to do yourself, unfortunately, but it is a very cool concept, and it's a great gift that you can give to your kids, that kind of protection over their inheritance to make sure that they're the person who gets to enjoy that money. Planning for incapacity. And I see here a question. What is it called again? It's the Lifetime Asset Protection Trust, or an asset protection trust. That's the concept, is it's protecting those assets from things like divorce and creditors in a bankruptcy. Planning for incapacity. This is something that has been very present, I think, for a lot of us over the last few years here. Is planning for incapacity, planning for who can make healthcare decisions for me, who can make financial decisions for me if I can't make those decisions for myself. And I have on the screen here pictured somebody named Terri Schiavo. And Terri Schiavo might bring to mind some associations. Maybe you remember her story. It was a relatively long time ago now. It was something like the mid-2000s when Terri suffered a cardiac event and ended up going into a vegetative state. And it wasn't clear how much Terri was able to interact with her world, how much enjoyment she was getting from her day-to-day life. It wasn't clear, but her parents believed that she was able to interact and that she was able to have a meaningful life still. And her husband thought that she wasn't able to interact, or she didn't have wouldn't want to be kept alive in the state that she was, in the vegetative state that she was. And so there were a lot of court battles. There were a lot of battles and conflict in this family. It ended up going all the way up to the Supreme Court on the national stage, where everybody was paying attention. And it was finally decided that the husband could remove the life support from Terri. All of that could have been avoided if Terri had put her wishes down and made them clear before something happened to her. And none of us expect something like Terri's story to happen to us. You know, and the risk is low. The risk for each individual one of us is really low. But none of us want the kind of conflict that her family had to go through, and the amount of strife and really nationwide attention that her case garnered. Nobody wants that. And it can be avoided by putting down your wishes in an advanced healthcare directive, where you can name a healthcare agent. You can tell everybody exactly who the person is that you want making decisions for you. And you can write what's called a living will that actually says, this is what I want for my healthcare. These are the things that I want you to do. If I'm in this situation, this is what I want you to do. If I'm in this situation, this is what I want you to do. So that's really a fantastic tool that you have that can really avoid a lot of conflict in your family. So we've talked about a lot of things today. We've talked about guardianship for minor kids, and we've talked about probate and how long probate takes to get through, as well as the cost and the public nature of probate. We've talked about the fact that probate is voluntary, but you have to be affirmative. You have to step forward and do some planning to make sure that you get to avoid probate. We've talked about estate taxes and how they don't apply to most people because the exemptions are so high on the federal level and on the state level right now. But they do apply to some people, and it is something that you can plan for and something that you can take care of. We've also talked about unclaimed property and how property becomes unclaimed and how important it is to make sure that all of your assets are known or can be found easily to get to the people that you want. We've talked about asset protection and building in asset protection over the inheritance that you give to the people that you love, and how great a gift that can be to them to make sure that those assets are protected. And we've talked about incapacity planning and who can make financial decisions for you and healthcare decisions for you. We've gone through all of these things, and probably at this point you're wondering, what can you do today to do the right thing for your family, and what should it cost to make sure that you have the right plan in place? So really your options are that you can try and do it yourself, or you can work with a lawyer. And keep in mind that not all lawyers are the same. So how do you choose? Would you benefit from working with a lawyer? And I generally say you would benefit from working with a lawyer if you own more than just your personal belongings. If all that you have in your name is stuff like a car, clothing, jewelry, furnishings, in fact, the number in Minnesota is $75,000. If you don't own any real property and you have less than $75,000, you might be able to do a do-it-yourself plan and get the result that you want from that plan. And the reason for that is probate doesn't actually kick in until the assets of an individual total more than $75,000 or include real property. So know that there is kind of a threshold for probate, a lower limit for probate. You could still work with an attorney, even if you have less assets than that. But it's kind of a dividing line where things are a little bit clearer, things are a little bit easier if all that you have are things like cars, clothing, jewelry, and furnishings. If you want to ensure that the people you love stay out of court and out of conflict and have someone to turn to when something happens to you, then it's pretty important that you work with an attorney. And if you want a kids protection plan, if you have minor kids and you want them to be protected in the short term and the long term, if you want to avoid probate and have a definitive answer that you're going to avoid probate, or you want to avoid estate taxes, or you want to protect your children's inheritance in something like an asset protection trust, then you really have to work with an attorney in order to do those things. And if you want a guarantee that your plan is going to work for your family, really, when it's needed, then you need to work with an attorney. And that brings to mind a story that I like to tell. It's a do-it-yourself story because I'm somebody who is a strong advocate for trying to do it yourself and trying to take care of things yourself, try and fix it yourself. And I had a situation where my son and I were going to go fishing, and he was really excited and I was really excited. We'd just gotten 2 new fishing poles and rods and reels, and we were excited to go, but they had shipped without any fishing line on them. Not a problem. I ordered some fishing line and was stringing up the fishing lines, and I got to the end of the first one, and as soon as I snipped the line, I thought that I had everything all set. As soon as I snipped the line, the fishing line just started jumping off of the reel. I don't know what I did wrong. I still don't know what I did wrong. But all of a sudden, the fishing line started jumping off of the reel, and I had this huge jumble of fishing line that was no good to anybody. It was a tangled mess. I couldn't straighten it out. It was no good to anybody. That's an example of a do-it-yourself project with minimal risk. I still don't know how I screwed that up, but I did screw that up. But there was minimal risk. There was a minimal cost associated with the risk of my failure. The only thing that I lost was some fishing line. It was maybe worth 30 cents, something like that was all that I ended up losing at the end of the day. And it was something that I was able to clean up and take care of, and we were still able to go fishing that morning. It wasn't something that prevented us from going fishing. I tell that story because estate planning is the exact opposite. If you make a mistake with estate planning, it's not going to be something that you can clean up. You're not going to be there to take care of the people that you love after your estate plan is supposed to have gone into effect. And making a mistake with estate planning, there's a lot of risk. It's very easy to make a mistake, and the risks are extraordinarily costly. And that's why I generally encourage people not to try and do it yourself with estate planning. Again, putting together IKEA furniture, the worst case scenario is, I don't know, your furniture isn't usable anymore, right? That's the worst case scenario, is you have to go out and buy a new piece of furniture. But even that is almost never the case with putting together IKEA furniture. And I see some people are struggling with sound issues. I'm sorry to hear that, but it looks like most people still have the sound. And so if you are having a sound issue, try popping out and popping back in here. But I tell that story again because doing it yourself with estate planning can go terribly wrong. And I have had to clean up a lot of estates where it's gone terribly wrong and hasn't led to the result. And I know the people who had written the estate plan were trying to avoid bad situations and ended up in a bad situation. Just one other point, if you want to give your assets to someone other than your kids, that's generally how things go in Minnesota, is that they go to your kids and then your grandkids and then your great grandkids, or they go up to your parents and brothers and sisters. If you want to give to somebody outside of that natural succession line, then you really want to make sure that you have an attorney to look over things and make sure that that everything's going to go the way that you want it to. And again, not all attorneys are the same. I want to bring you back to this phrase that my parents said about a very negative estate planning experience that they had with an estate planning attorney. Someone has to graduate at the bottom of the class. And again, I don't think that it was this attorney's intelligence. I don't think it was this attorney's knowledge. I think it was the model that this attorney was planning under, which again, I call planning for death. And this is what that looks like. The typical experience with a typical estate planning attorney is that you're going to get form documents, and you'll probably get those documents, not understand them real well. You'll figure it's kind of a set it and forget it thing. You'll put them in a bottom drawer, likely never look at them again. And maybe they'll work in the future, maybe they won't. But oftentimes they aren't going to serve you in the way that you're hoping they're going to serve you. Typical experience means that you're not going to keep your money out of the Department of Unclaimed Property. It's just not something that most estate planning attorneys are looking at or considering. But I think that that's really important. Again, as a father of 4, I'm still building my wealth. I'm still building the inheritance that I want my kids to receive. And it's especially important to me right now when I'm still building that inheritance that they receive every dollar that I want them to, every dollar that they should receive. And that's why it's so important to keep the money out of the hands of the Minnesota Department of Unclaimed Property. Typical experience may avoid probate, but it may not. In fact, I know a lot of estate planning attorneys that just plan for probate. And this was kind of how I was taught, was you just plan for probate. It's too difficult to try and avoid. And you just deal with the probate when it comes up. But I don't think that that is a good way of planning. I don't think that that's a good way of serving clients. Probate is avoidable, and don't listen to a typical estate planning attorney who tells you that it's unavoidable. Typical experience probably isn't going to keep your family out of conflict. Family dynamics often aren't brought up at a typical estate planning meeting, or a meeting with a typical estate planning attorney. They're more interested in the assets that you have and just dealing with those assets, regardless of what the family dynamics might be. Typical experience is only going to focus on the money, not your stories, not your values, those intangible assets that you likely want to share with the people that you love. It's going to leave assets to heirs unprotected without that asset protection that we talked about built in. there isn't going to be ongoing legal guidance because that attorney is likely to be charging hourly fees. And that really is an impediment to creating a relationship between attorney and client. It means that you're not going to want to reach out to them because you know that you're going to get a bill in the mail 2 weeks later if you do reach out to them. Typical experience also isn't going to adequately protect kids. Generally, they do a long-term guardianship nomination, but they don't take care of the short-term, the immediate needs of the kids and making sure that those are covered. And it's going to leave you with this question: is my plan going to work when I need it to work? And that's not a question that you should ever have after you work with a lawyer. Planning for life is totally different, and that's what I do. I plan for life. It's a totally different experience. I only charge flat fees, and you actually get to choose the fee. And that doesn't mean that I'm just hoping that you'll donate enough that I can keep food on the table and clothes on the kids or anything like that. But the flat fees are all laid out, and you can choose exactly what you want for your family. And we'll talk about it. And we'll talk about what the cost is going to be, and we can decide if that's the right way to go. We can decide what matches your finances and what matches what you want to have for your family. Planning with me means keeping the money out of the hands of the state. Again, it's very important that you have an inventory in place so that all of your assets can be found when something happens to you. Unfortunately, we are all going to die someday. It's a sad fact of life, but knowing that can also be kind of a relief, because we know that we need to plan. We know that we need to keep track of our assets to make sure that they're available to the people that we love after we're gone. Planning with me means that you can protect your kids totally, both their immediate and long-term care. Planning with me, it means keeping your family out of court and out of conflict. I am very passionate about helping people to avoid probate and make sure that they don't have to go through, or that their family doesn't have to go through that probate process. Planning with me is going to mean that you know that you've made the right decisions. I believe in educating and empowering my clients. I believe in talking them through things and making sure that they completely understand their plans and really make sure that they're the ones who are making the decisions. I bring my knowledge, but you bring your understanding and your knowledge of your family. And that's extremely important when we're making decisions that we consider, and that you are able to consider that information and make decisions on your own. Planning for life means protecting family money from outsiders, things like divorcing spouse and creditors in a bankruptcy. It's such a great gift that you can give your kids to be able to protect that money. And planning for life means a lifetime of guidance and protection. That flat fee includes all of our future communication. That's emails, phone calls, that kind of thing. If there are changes to your plan that need to happen in the future, we'll agree on what a reasonable fee would be to make those changes in your documents. It does take time. It does take time to execute those documents a second time. And unfortunately, I don't know what your future holds. You likely don't know exactly what your future holds. So I do have to charge for changes to a plan, but I don't have to charge for phone calls, and I don't have to charge for emails. And that allows us to keep the lines of communication between us open so that we can make sure that if there are changes going on in your life, I know about them and I can tell you whether or not it's going to affect your estate plan. Planning with me, it means that you know that your plan is going to work when your family needs it to work. And again, it's really a gift that you're giving to the people that you love, the people that you want to receive. So let's talk about cost. What should you expect to pay to have an estate plan done by an estate planning attorney? And I can tell you this planning is going to save your family at least $12,000 if all that you have is a house worth $400,000. I understand for some of us, that seems like a pretty nice house. That seems like a pretty luxury house. But the way that real estate has been going right now, it's kind of been going gangbusters. And so, 400,000 might not seem like a very posh house to you. I don't know. We're all coming to this from different places. But if you have that $400,000 house, 3% of that value is $12,000. So you're saving, that's the bare minimum of what you can expect in probate fees. And you can avoid that probate fee by getting an estate plan in place. If you have assets over $3 million here in Minnesota, where the estate tax exemption is $3 million, then this planning is going to save your family at least 13 cents on the dollar for every dollar in excess of $3 million. A typical plan from a typical death plan type, typical estate planning attorney is going to charge a minimum of $1,500. And you can almost guarantee it's not going to keep your family out of court or out of conflict. It's not going to ensure your assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your money. It's not going to cover your kids' immediate care, nor your values, insights, stories, and experience. Those most important intangible assets that are often the most lost assets. The alternative is you can plan with me, and I'm a personal family lawyer, and learn specifically what your family needs. And again, you can choose the fee that fits your situation and your finances best, and that fee is likely to range somewhere between $2,000 and $8,000. And I can tell you most people who plan with me fall at about the $4,000 to $5,000 level. And you're going to know that your plan is going to work when your family needs it to work. And I want to make this really easy for everybody. I'm going to go ahead and share the link here in the chat. Hopefully this works. Nope, it wouldn't, but I can make it work. I know that. Give me just a second, and I can share the link to my calendar so that everybody can see it. And I know that there are some questions here, and I promise that I'm going to get to those questions and answer them. Give me just a minute and I'll have some time to answer those questions, okay? Everybody should be able to see that link to my calendar. Go ahead and click through. And when you click through, make sure that you click on Family Wealth Planning Session, and you can see what my calendar looks like. And it's likely that you're not going to see any time available here in September anymore. We're getting towards the second half of September, but you're going to see time available in October and November. And I encourage you to take a look at it and choose a spot that's going to work for you. Make sure that you get on my calendar that Family Wealth Planning Session. I'm offering you that for absolutely free. And it's valued at $750. The reason it's valued at $750 is that it's 2 hours where we're going to sit down and we're going to talk about your assets. We're going to talk about your family, and we're going to talk about your estate planning needs and what you want to have happen. And we can get very specific to your situation, and we can get very specific to what you want to have happen. And I can tell you exactly what the laws of Minnesota say and how we can make sure that things are done in the way that you want them to be done. In addition to that absolutely free, no obligation session, I want to give you $250 towards the plan of your choice. And again, those are the flat fee packages. We'll go through them at the Family Wealth Planning Session. If you choose to do a plan with me, again, no obligation, although most people do continue and do want to do a plan with me at that point. If you do want to do a plan with me, I'm going to give you $250 towards that package of your choice, so long as you book your Family Wealth Planning Session before the end of the week. The Family Wealth Planning Session isn't going to happen before the end of the week, obviously. But if you get on my calendar between now and the end of the day Saturday, I'm really happy to give you that $250 towards the plan of your choice. And the reason is this: estate planning is a momentum thing, and you have the momentum going in your favor right now. You showed up here tonight, you've educated yourself, and you have the ball rolling. Now is the best time to take the next step and to get on my calendar and to continue this conversation and to make sure that you get your plan written for you. If you decide, maybe I'll wait and maybe I'll think about it a little bit, maybe I'll get on his calendar here in a week or two or maybe a month. What I've often seen happening is the momentum gets lost and this falls off your to-do list and it doesn't get done. And I don't want that to happen for you. And honestly, it's not just your well-being that I'm thinking of. The $250 that I'm offering you also ensures that I don't have to do a bunch of follow-up. I don't have to put email campaigns in front of you, and I don't have to follow up with phone calls, and I don't have to try and track you down in order to make sure that you get on my calendar and that you get this done. It saves me time, it saves you time, and it makes sure that you keep the momentum running. And that's why I'm really happy to give you that $250 gift. What does estate planning with me look like? Well, I can tell you I have all 5-star reviews on Google. My clients are overwhelmingly positive, and a big part of that is the fact that I educate and empower my clients to make the decisions themselves, and I make it simple for them to do so. So here are some of the things that my clients have said about me that you can go ahead and read through as I am reading through and answering some of these questions, because I do see that there are some questions. And I see one of those questions is, if a person uses a bank as a trustee, like the trust department, how does that work? Who oversees it, and what are the costs? That's a fantastic question. So if you use a bank as a trustee, they're going to be administering that trust based on the rules that you've written in your trust agreement. They're very good at it. They do it for a lot of different trust agreements and a lot of different families. And so they definitely understand it, and they'll generally assign a case manager or a trust officer who is going to oversee your interactions with the company, and they will just follow what's said in the trust. The cost is generally something like 1% to 2% of the value of the assets that they're overseeing every year. And so you can imagine, if you have $1 million in assets that they're overseeing, they're going to be charging something like $10,000 to $20,000 a year in administration fees. It's expensive, but again, they're professionals. They're very good at it, and it can be a good option in some cases. Someone else is asking, if we move to a different state, what if we move to a different state in a few years? Can we continue to work with me? And the answer to that is yes. I am a personal family lawyer, which means that I have a network of different personal family lawyers I connect with across the United States. And so if you move to a state that has different laws, often what will happen is I will co-counsel with an attorney in a different state so that I can make sure that you get the best treatment under the laws of that state, but that you're able to continue working with me, somebody that you've developed a relationship with and that you know that you can talk to. Another question, typically, how long does the process take to set up a living trust for a married couple with minor children? It's a fantastic question. Generally, after we have the family wealth planning session, you're looking at about 4 to 6 weeks before we can get together and have the signing meeting where your trust will actually be in force, where it'll actually be a living, acting trust, as well as the guardianship documents will also be effective at that signing meeting. So that's about what you can expect. It's about 4 to 6 weeks after the initial meeting. And that initial meeting is, again, the family wealth planning session. You can click through my link and you can take a look at my calendar. Family wealth planning session is can be a totally virtual session. In fact, that's actually my preference. It makes it easy for me because I actually have a virtual office. So the alternative, if you don't want to have a virtual meeting, and I know a lot of us are kind of zoomed out right now, although you're with me here on a Zoom, which is good. No, I don't recommend all 3 appointments, just the 120-minute appointment for now. That's the family wealth planning session. Just book that one. If you have something that you want to talk with me about before the family wealth planning session, you'll find that my 15-minute, my phone consultations are more accessible, that there are more of those phone consultations that are available. But otherwise, I just encourage you to schedule the family wealth planning session right now. So the family wealth planning session, again, it's totally virtual. At first we get acquainted, and then we start talking about things, and we talk about who would be the person to collect everything for you, who would be that person who would step into your shoes for you, and what would you want to have happen if you became incapacitated, and do you think that your family would honor that? Do you think that they'd carry that out, or is that something that we especially need to make sure that we get documented and that we get legalized for you? And what would probate look like for you? What would be the time? What would be the cost that you could expect from probate? What would the process look like for the people that you love? Would you owe estate taxes? And we'll talk about that based on what your assets look like. Would you owe estate taxes, and how can we plan around that and make sure that we have either assets in place to pay for that estate tax, or that we're able to plan for it and avoid that estate tax, which is often preferable for my clients. How do you want the people that you love to receive your assets? And that might be everything all at once. It might be those asset protection trusts that we talked about. And we can talk about all kinds of different ways that we can make that happen. Again, after that family wealth planning session, I'm going to confirm everything with a confirmation document called the Confirmation of Important and Missing Information. And then I draft your documents from that confirmation. And because I have that virtual office, I office out of my home, I generally travel to my clients for the signing meetings, which is a huge, huge advantage. I'm able to come to your house to sign documents with you. And that signing meeting is where your documents are going to become effective. And again, we can have those documents in place in just 4 to 6 weeks after we meet the first time. But that's why it's so important to make sure that you take a look at my calendar and get a time that's going to work for you, to make sure that you're on my calendar and that we're able to meet. Then after we have our signing meeting, there's a third meeting that also happens called the Family Wealth Legacy Interview. And that's the meeting where you get to share your values, your stories, your insights in a recorded interview that we keep for the people that you love, so that they can have that part of you after you're gone. So the next steps here, again, take a look at my calendar, schedule your free family wealth planning session, and in that family wealth planning session, use the $250 gift that I want to give you towards the plan of your choice. And I see somebody asking, do you offer times after 5 p.m.? We work 8 to 4 Monday through Friday. And what I say to that, what I recommend, schedule a 15-minute phone consultation at a time that works for you. And we can talk about finding a time that's going to work outside of that regular window. I'm kind of like you. I have 4 kids. I have a family here at home, and I love spending time with my family. I spend a lot of time with them, but I do sometimes offer times outside after 5 p.m., or I do sometimes offer times on Saturday by request. But those times are really limited, and if at all possible, please try and find a time that's in the working day and the times that I have offered on my calendar. I'm looking to see if there are other questions. Again, I love answering questions. If you do have questions that I haven't answered, or you want some clarification on something that I have addressed, I encourage you to put it in the chat or to put it in the Q&A box. Some questions that I often get are about supplemental needs trust or special needs trust. And a special needs trust or a supplemental needs trust is a trust that holds assets for somebody who is receiving government benefits. And so that SNT will hold on to the assets so that the person doesn't become disqualified from receiving the government benefit. Maybe it's a government benefit for food, maybe it's a government benefit for where they're living, something like that. But oftentimes it can be very harmful if they receive an inheritance, they get knocked off of whatever government benefit that they were receiving. They end up spending down that entire inheritance on necessities that they had in place, and then they have to reapply for the government benefit after all of the money is gone. And that can be very disruptive to somebody's life, especially if they have things going on, if they have a disability or something where they need that government benefit. I see here, what if we move out of state in a few weeks after setting up the trust in Minnesota? In a few years, not weeks. Yeah, and that's a great question. If you move out of state, the laws of Minnesota would still apply if you didn't change anything about your estate plan. But there are some states where there are advantages to having that state's laws apply to your plan. And so it's just very important that we keep a conversation going, and you let me know if you're considering moving out of state, and I can let you know if that's one of those states where you might want to make sure that the laws of those states are going to apply. And you might want to make sure that the plan is rewritten to use the laws that are in that state. Wisconsin is one of them. That Wisconsin is a community property state, and what that allows, it allows a double step up on property after the second person dies. And it's complicated, but essentially what it means is that that there's a cost basis. And you can imagine if you bought a stock and the stock was $10 and then the stock went up to $100 and you sold it, well, you would have $90 in gain that you would have to pay tax on. You have the $10 original purchase price. You don't have to pay any tax on that. But the $90 between that 10 and 100, you do have to pay some kind of tax on that. That's income, considered income to you, or gain to you. Well, in Wisconsin, if the first person passed away and the stock was worth $50, the value of it's like the value that they purchased it at is stepped up to $50 when they die. So if the other spouse decided to immediately sell that stock, they could sell it for $50 and they wouldn't have to pay any gain. They wouldn't have to pay any income tax on the sale of that stock. And then when the second person passes away, they get another step up in basis. And that second complete step up in basis would step it up to $100 so that the kids wouldn't have to pay tax on the sale of that stock at all. It would be stepped up to the fair market value at the date of death. We have that same step up in basis in Minnesota, but we don't have a double step up in basis in the way that they do in Wisconsin. And it's just unfortunate, but we have community property, which is a little bit different. Minnesota does not have a stepped up basis for property like investments in real estate. We do have a step up in basis, but we don't have community property. We have what's called separate property. And that means that that only part of it is stepped up on the second death. There are ways to work around that and to avoid that and to make sure that the entire step up happens, but that's the high and low of it. Like federally, yeah, it's a good question. I feel like I'm getting a little bit too into the weeds, and it's getting a little I'm confusing people, and I'm not trying to. We do have a step up in basis in Minnesota, and the step up in basis works here, but it's just a little bit different character, and there's some advantages to recognizing to having the Wisconsin step up in basis as opposed to the Minnesota step up in basis. And we can talk about that in more particular. There are a lot of other advantages in Wisconsin, like there isn't an estate tax. That's a huge advantage. And the same thing with Florida and Arizona, places without an estate tax. That's a huge advantage to people if you have more than $3 million. I do see a question here. What happens if something happens to me? And that's a fantastic question. I have an agreement with another estate planning attorney to take my files if something happens to me, and I've agreed to take his files if something happens to him. So that's a short answer to that question. A longer answer is that the estate plans that I write can be interpreted and read by any estate planning attorney in Minnesota. So you're not just locked into working with me because I've written your estate plan. Those estate plans can be read and understood by any estate planning attorney, or really any attorney in Minnesota. But I think that you'll probably want to continue working with me because I develop a relationship with my clients, and it's easy to continue working with the lawyer that you've started working with. All right, is there a minimum amount of assets needed to complete a trust? For example, 1 million in total assets. That's a fantastic question. I don't recommend that everybody do a trust, and that's just the fact of the matter. And it's not necessarily tied to a specific number either, like $1 million or $500,000. It's more in the way that you're holding your assets. So I have done estate plans before for people who have more than $1 million, but because of the way that they held their assets, most things were in retirement accounts. Their kids weren't minors. The only other thing that they had was a house. And in Minnesota, we have what's called a transfer on death deed, which actually transfers the house by beneficiary designation, basically after the survivor has passed away. Because of the way that everything lined up, it made more sense to save the money, not do a trust for them, and just have things set up so that they could continue. They could still avoid probate, but that they didn't have to complete a full trust in order to make it work. So that's something that I always look at with clients. We always consider all of the options. But I've also written trusts for people who have much less, who have only 300,000. 400,000, even less than that. because it just made sense. It just made sense for the way that they held their assets, the fact that there were a lot of bank accounts and the kids were minors, or they had a lot of bank accounts and there were kids that might fight if the money went to somebody or went to multiple people, or maybe somebody wasn't good with money and couldn't be trusted not to spend that money on things like drugs or gambling. And so there were times that we did planning for a significantly lower amount. That's something that we definitely talk about in the family wealth planning session. And I'm not going to recommend that people do unnecessary things, but we're going to talk about what you want to have happen for your family and the easiest way to make sure that that happens. And I will help you to do that. I see somebody saying, if we have a will and now want to create a revocable trust, do we need to redo the wills? That's a fantastic question. You do redo the wills, and you actually redo the will with something called a pour over will. And the pour over will is a very simple will that just says, if we have something that we forgot to put into the trust, if there's something in our personal name when we die, put that asset into the trust. Put it into the trust. Unfortunately, it means that you would have to go to probate in order to get that asset into the trust, but it's kind of a backup plan that we have, a backup mechanism that we have to make sure that everything goes into the trust and is administered based on the terms of the trust, which is where we want everything to be administered from. And then somebody's asking, what's the difference between a revocable and an irrevocable trust? Man, you guys, these are fantastic questions. I really appreciate everybody's questions tonight. They're really great. The difference between a revocable trust and an irrevocable trust is the fact that a revocable trust can be amended or revoked, and an irrevocable trust cannot. It is now in place. It's like it's written in stone. Oftentimes with a revocable trust, the creator of the trust, called the settlor, and the trustee are the same person. And in an irrevocable trust, oftentimes the trustee is not the original settlor of the trust. And that might be the case. A revocable trust becomes irrevocable when somebody passes away. And so that's something that happens as well. But also, oftentimes people will do an irrevocable trust to plan for things like nursing home care, or they'll do an irrevocable trust to hold something like life insurance proceeds to make sure that that asset doesn't have to go through an estate tax treatment after the person is gone. So it's a way to plan for estate taxes. It's a way to plan for nursing home care. That's what the irrevocable trust is. But you have to give up control, and you have to give up the ability to revoke or amend that trust. That's what makes it irrevocable. It seems having a trust will pay for itself versus cost of probate. That's exactly right. For most people, if you own a home, almost always the cost of a trust will pay for itself versus the cost of probate. That's exactly right. And that's why a trust is often the way to go versus having just a will in place and planning to go through the probate process. Yep. Well, I hope that you've had a chance to click through to my calendar and find a time. Know that I am going to email out a recording of this webinar a little bit later. I'm going to try and do it a little bit later tonight, but it might come out tomorrow morning. I'll try and do it tonight. I will also send the link to my calendar if you haven't had a time or if you haven't been able to pick a time, or maybe you need to consult with a spouse or consult with childcare or something like that in order to pick a time. I will send out that link, but I hope that you'll get on my calendar. I hope that you'll get on my calendar before the end of the week, which again is the end of the day Saturday, so that you can get this ball rolling and so that you can get that $250 gift that I really truly want to give you. I want you to take advantage of this and have that $250 gift. Seeing somebody say, thank you, Tim. Fantastic presentation. Talk with you soon. Fantastic. I'm looking forward to talking with you. Thank you, everybody, for being here tonight. You've educated yourself, and you really deserve kudos for being here and for educating yourself and getting this ball rolling. I appreciate you being here. I appreciate you sticking with me, even though we're past the 8 o'clock hour. You had such fantastic questions. It was really a joy answering them, reading them, and answering them. So I look forward to seeing you in a family wealth planning session, and I hope that everybody has a fantastic night. Bye.